Hello, this video is going to talk about confidentiality and privacy policies in the context of recovery residences and is a part of the recovery residence manager training. So there's always this question, does confidentiality and privacy, is that a relevant topic to recovery residences? And I'm hoping by the end of this video that your answer is going to be, well, of course it is. Most recovery residences collect sensitive information. I'm talking about information like personally identifiable information. This is their name, social security number, biometrics, date of birth, as well as health records. Oftentimes we are collecting health records such as medications, even to make sure that we don't get a false reading on our UAs or misinterpret a UA. So if they do apply, then what confidentiality or privacy laws apply to recovery residences? And it really depends on so many different factors. And I probably want to step back and even frame it as, so there's legal and then there's ethical. And we're going to talk more about this in a separate video. But legal, that's kind of like the bare minimum. That's like, what do I do to not break the law? And then ethical really is asking this question, what's the right thing to do? What are residents' expectation of confidentiality and privacy? What's the residents' rights? What agreements have we either verbally or written gotten into either with the residents or any of our stakeholders? And then one of the things that we'll talk about towards the end of the video is with the recovery movement, there's been some really innovative stuff about empowering residents, empowering the persons in recovery themselves to own and manage and control more of their own information. And we'll be briefly talking about this program called RECAP. So all recovery residences should have confidentiality and privacy policies and procedures. They should be written. Everybody should be aware of them. Staff should be trained, and to some level, residents should be trained, especially on particular policies and procedures. They should be enforced, and they should be periodically reviewed and updated. Policies and procedures often differ across recovery residences, and that could be across levels of support and really kind of depending on so many different variables that we'll be talking about in the upcoming slides. What I should say, so one size policy and procedure does not fit all. So what are some potential privacy laws that we should be aware of? Well, you've probably heard of HIPAA and 42 CFR. HIPAA stands for Health Insurance Portability and Accountability Act, and 42 CFR is specific to substance abuse treatment programs. So we're not going to do an in-depth look at either one of these, but I really encourage you to, as a part of your field experience hours, to research these on your own. Maybe you even like to make a video or some educational resources around these two that you could bring to the community of practice and help educate your peers or engage in a discussion around these two with your peers. But for this video, we're just going to mention them and then move on to some of the other topics. So when we think about licensed programs, licensed treatment facilities, licensure happens at the state level. And so there could be some state statutes, some state policy, administrative policy that really dictates what policies and procedures that you may have around confidentiality and privacy. Because some recovery residences, remember all level 4s, are licensed by the state. And other states, not Texas, there are some licensed level 3s that are licensed by the state. In addition to that, we're seeing this trend around combining recovery housing and outpatient services. So if there is a kind of one-to-one relationship between the recovery house and say PHP, meaning everybody in the house is enrolled in the same PHP, that's oftentimes called the Florida model. And so this is a great example of how the requirements around that treatment component can really impact the policies and procedures that would be found within the recovery housing component. And even if there's not this one-to-one relationship, oftentimes we have tight relationships with licensed service providers out there, and that can also impact what policies and procedures around privacy and confidentiality that we should have within the recovery house. And that kind of gets to this slide. What are the referral requirements? Either, we could have something formal like a memorandum of agreement. We're moving more towards this recovery-oriented system of care where there's this whole, system of stakeholders that are working together and supporting an individual as they move through the system and seek recovery. And so that's a kind of one way of formalizing those relationships within a recovery-oriented system of care is through the use of memorandums of agreement, MOAs, or memorandums of understandings, MOUs. So easily we could see a kind of an expectation around confidentiality and privacy set within these MOAs. So also we should be thinking about, so who works within our recovery housing? Staff may have legal and or ethical requirements associated with their professional license or with their credential. They're obligated to adhere to those requirements even if they're not in that staffing role. So for example, if a licensed chemical dependency counselor was working in a recovery house manager or even a recovery coach role, they can't ignore their professional obligations while working in that peer role. There's also funding requirements, or I should say, there are privacy policies and confidentiality policies that can be driven by the type of funding that you're getting. So for instance, it's very common that if you're getting city county dollars or state dollars or federal dollars, that funder has put certain requirements around privacy and confidentiality into that agreement. If you're agreeing to take their money, then you're also agreeing to operate according to a certain level, and that could include privacy and confidentiality. So you need to be aware of what your contractual agreements and requirements are. Also, if your recovery residents or the residents within your recovery home are engaged in research, there are specific federal regulations for the protection of human subjects and research. They've evolved over time, really, and increased over time in response to the increasing awareness of ethical issues, including privacy and confidentiality. So if any of your residents or your recovery home is participating in research, then I would encourage you to do a deep dive around this and learn more about what the privacy and confidentiality requirements are in order to protect your residents. There's also this thing around risk management. So sure, there's the legal thing, and then there's the what's right to do, and then there's risk management. What are the expectations? Oftentimes residents and their families have a hard time distinguishing between a recovery home and a treatment provider. They may not distinguish between providers who are legally required to secure privacy and confidentiality from those that are not legally required. They may have an expectation of privacy and confidentiality that you weren't prepared for. And they may take legal action if damages occur due to the breach of privacy and confidentiality. And I'll take us back to one of those first slides that highlight that as recovery houses, we oftentimes do collect private information. So consent forms are a really important tool. This protects residents' rights via agreements. Residents can provide written permission to share specific information to specific individuals for specific lengths of time, and they can revoke that permission at any time. So I talked about there were some innovative things going on in the recovery movement that's really kind of shifting the responsibility or empowering individuals to control their own privacy, their own information. And an individual, just like we talked about with the consent form, can share information. And so there's been this really cool thing that has formed just in the last couple of months called RECAP. It's an online recovery capital self-assessment. Residents own their own information. Information is stored online behind username and password, and it's the resident, the individual in recovery, that invites or authorizes permission-based access to others. And because they're in control of it, they could go in and remove that permission. So this is, I think it's a really cool idea. It kind of flips everything on its head, and I suspect that we'll see more of this type of approach to privacy and confidentiality in the future. So, what are your resident manager's duties? Well, make sure that you adhere to the privacy and confidentiality policies and procedures of your particular recovery residence. If you don't know what those policies and procedures are, then go talk to your owner operator. If you don't have any, then you may want to encourage them to develop some based on all the number variables that we talked about today. Examples could include secure information behind double locks and with limited access to that information. Don't share information unless allowed by the residents via a consent form, and or empower residents to collect, assess, manage, and or share their own data. So thank you for taking the time to listen to this video. Confidentiality and privacy does apply to recovery residences. One size doesn't fit all, so you need to be aware of the various variables that can impact good policies and procedures. And I look forward to seeing you online.